This matter is before the court as remanded by the Appellate Division order dated February 3rd, 2023. Therein, this court is instructed to issue written amplified findings and a statement of reasons to facilitate appellate review. In the narrative of its order, the Appellate Division found that this court abused its discretion in not considering the defendant's proffered evidence of self-defense to the murder charge. Further, the order instructs this court to give reasons for finding defendant is a flight risk or would attempt to obstruct the criminal justice process. A little bit of background on this. Defendant is charged in the complaint warrant with murder by shooting her husband. Murder is a charge for which, under New Jersey's criminal justice reform statute, there is a presumption of detention. That's at NJSA 2A:162-19B. That presumption of detention may be rebutted. NJSA 2A:162-19E2. And that is as follows, quote, the standard of proof for rebuttal of the presumption of pretrial detention shall be a preponderance of the evidence. If proof cannot be established to rebut the presumption, the court may order the eligible defendant's detention. If the presumption is rebutted by sufficient proof, the prosecutor shall have the opportunity to establish that the grounds for pretrial detention exist pursuant to this section. The posture of this remand comes down to this. Did the defense present sufficient evidence to overcome the presumption of detention? At the initial detention hearing, this court answered no and ordered detention of defendant. However, this court is now tasked by the Appellate Division with deciding whether the proffered evidence of self-defense rebuts the presumption of detention to the standard of a preponderance of the evidence. As to the quantum and weight of the evidence presented at the detention hearing, the court notes that, aside from the affidavits, character letters, and photographs submitted by defense, most of the facts which the court was asked to consider were by proffer. The state relied upon the affidavit of probable cause at pages 5 and 6 of the complaint warrant package. The relevant information therein is as follows. On 12/25/22, the Hamilton Township Police Department responded to 5231 Mays Landing, Summers Point Road, for a 911 emergency request from Marylue Wigglesworth in reference to her being in an altercation. Officers responded to the location, and upon arrival, they located Marylue in a bedroom with her husband, David Wigglesworth. David was suffering from gunshot wound and was later pronounced dead. Marylue advised the officers that she had shot her husband. A handgun was located in the bedroom where David was located. Close quote. Nowhere in that affidavit is there an assertion by the defendant of self-defense. Nor was the court provided with a police report containing such assertions, although defense counsel stated in an argument that, quote, she, the defendant, stated at least 6 times to the officers that there was a fight and an altercation, close quote. The defendant apparently did not elaborate for the police what that, quote, fight and altercation, close quote, entailed. If she did so, this court was not provided with that information at the detention hearing. As to the pictures of the bruising on the defendant, the court accepts that the defendant had bruising, but there is no way of knowing how and when those bruises occurred. Further, the court was asked to accept that they are bruises indicating a necessity for self-defense. Without medical testimony or other such support, the court would be, I'll stop just a minute. There's an overhead announcement in the courthouse. Again, I'll start again. Further, the court was asked to accept that they are bruises indicating a necessity for self-defense. Without medical testimony or other such support, the court would be speculating as to the defensive nature of the bruises. The defense also provided 14 character letters / affidavits in support of defendant's pretrial release. Notably, most of them only speak to defendant's reputation as a good person in the community. None of them speaks to what happened between the parties on December 25th, 2022. The only affidavit or letter which speaks of physical violence between the victim and the defendant is that of their son. But he does not recount what specifically happened between his parents on December 25th, 2022. Thus, the court finds that neither the letters nor the affidavits contribute to the evidence of self-defense. The conclusive factor as to whether this court finds that the evidence of self-defense to overcome the presumption of detention is this. The state asserts, again in reports which are not provided to the court but provided by proffer, that, quote, the defendant stated that she went and got the gun and then came back and shot him, close quote. Also, the state asserts that the victim was naked in bed watching television at the time that he was shot. To this court, an assertion of self-defense rings hollow in this circumstance. Defendant had time to cool off and to choose a different path of behavior rather than leaving the room, retrieving a gun, returning to the bedroom, and shooting her husband. This court finds that the evidence which defense has presented as to self-defense does not overcome the presumption of detention by a preponderance of the evidence. Further, even if this court found that the presumption was overcome, this court would detain defendant on the basis of the victim/community safety prong of the criminal justice reform triad. The court acknowledges that on the evidence before it, there is no indication that defendant will not appear in court when required, nor that she would obstruct or attempt to obstruct the criminal justice process. Defendant has no prior record, and the public safety assessment scored her a 1 in the failure to appear and a 1 in the new criminal activity categories. But the community safety issue carries heavy weight with this court. She is no longer a threat to the deceased victim, but this court is concerned that a person who would mortally shoot a person lying in bed naked would have no compunction in behaving in an antisocial and criminal manner in the community at large. I'll note for the record that the appellate division did not retain jurisdiction over this remanded matter. So if the parties are not satisfied with the court's determination today, you may seek advice from the appellate division as to any further possible remedy. Finally, this court's order of January 3rd, 2023 remains in effect, and this written amplification shall be filed in the case jacket as part of that order. And that will conclude this matter. And within, I would say within an hour, attorneys, the court's amplification will be filed in the case jacket on eCourts. Thank you.
Thank you, Judge. Have a nice day.
Can I be placed in the breakout room for a minute with my client?
Yes, you may.
Myself
Thank you,
also,
Your
Your Honor. If all three of us can go in the breakout room, please.